Hello, everyone, and welcome to the Employment Law Counselor Podcast presented by White & Williams, LLP. I'm your host, Jeff Stewart, and each and every episode we tackle the laws and regulations that make up the world of labor and employment law. Today, we'll be covering misclassification of employees. Are they exempt or non-exempt? Questions that you need to ask. While our podcast is not legal advice, it is a practical discussion between two attorneys that deal with the maze and minefield of labor and employment laws on a daily basis. If you like what you hear, subscribe so you never miss an episode. As always, I am joined by one of my colleagues here at White & Williams to discuss our topic of the day. Today, I'll be joined by Jim Anelli, who heads up our labor and employment group and practices out of our Newark office. How are you doing today, Jim?
I'm doing great, Jeff. Nice to be doing this show. I look forward to it.
Welcome to the podcast. This is your first episode, so welcome to this.
This is my first one, Jeff, and please be gentle.
I will do my best. So why don't we dive right into our discussion? So, Jim, we're going to talk about exempt versus non-exempt, and these are terms that a lot of people get confused at times. Why don't you just give our listeners a general overview of what does it mean to be an exempt employee?
Sure. When we talk about exempt employees, what we're talking about are employees who are not subject to overtime requirements in connection with the amount of hours that they work. So effectively what that means is an employee can work more than 40 hours a week and not be subject to overtime for those hours. They're going to be salaried employees in most instances, or they can be, different types of exemptions that we'll get into later on in the program. But for the most part, that's what it means.
Okay. And when we think of exemptions, there are really the common white collar exemptions that we deal with, which are the executive exemption, the professional exemption, and the administrative exemption. But there are also some what I'll call oddball exemptions, which are exactly what I'm saying. And it's basically positions that are exempt from overtime simply because Congress at some point decided they should be exempt. And when I say oddball, I'll give an example. If you are tapping the sap from a maple tree in order to make maple syrup, you are exempt from overtime. Why? Because Congress declared it at some point because the syrup lobby decided they didn't want to pay overtime and lobbied Congress. But for the most part, when we're talking exemptions, we're talking about those white collar exemptions, which are, people you normally think of as professionals and salaried. Right, Jim?
Yeah, that's right. I think most people have an understanding that, the bosses, the supervisors are working long hours and they're getting compensated on a different way than on an overtime basis. So that's what I think most people in the workplace kind of envision as the executive or white collar exemption are individuals who supervise employees.
And the white collar exemptions, all of them have a two-part test. There's a salary portion and a duties portion of each test. Now, the salary portion is that they must earn at least $684 a week under federal law. Now, some states may have higher numbers, and federal law there have been proposals to increase that number in some places significantly. But as of right now, it is $684 a week. Now, Jim, there's also a duties part. Do you want to explain, in broad strokes, the duties tests for these exemptions?
Right. So the duties test are, for example, at the executive exemption, an employee has to supervise two full-time employees or the equivalent of two full-time employees. And that's where a lot of employers run into problems is they have even a high-level executive who may be eligible for one of the other exemptions we'll be talking about, but they don't supervise at least two full-time employees. And in those types of circumstances, they would fail to meet the duties test. And I think one of the things you mentioned just now, Jeff, that is important, you mentioned state law, that other states can have a greater salary test. Well, other states can also have a different duties test. And so when we talk about the exemptions from overtime, it's really critical to understand that there is a two-part test, sure, duties and salary test, but there's also different tests at both the state and the federal level. While many states do follow the federal standards, many do not. And so that's where a lot of employers get into trouble. But, getting back to the duties test, that's what's required for the executive test. There's another test called the professional test, or professional exemption, I should say. And there's a test in connection with the professional exemption. Another type of exempt status deals with administrative exemptions. And we'll be talking about those, but in general, it's important to understand that with respect to the administrative exemption, that doesn't mean that every administrative employee is qualified for that exemption. And one of the things that's really important in understanding these tests is how the Department of Labor, this is the federal Department of Labor, has construed these tests. They've construed them very narrowly. And most employers, if they apply the administrative test to administrative employees, will definitely wind up misclassifying non-exempt employees as exempt. And it's a common problem in that particular category. With respect to professional exemptions, once again, it's a very narrow exemption. It's not just that an individual is quote unquote a professional or that the individual has a college degree. What has been noted by the Department of Labor in order to qualify as a professional exemption is that the individual has to have years of experience and extended, secondary education and training with respect to a particular position. It may be enough if they don't have, say, an advanced degree, if they have years of experience. But simply because somebody, may call themselves a professional is not going to meet the standard as applied by the Department of Labor.
That's very true. And I always tell my clients the title doesn't mean anything. It all comes down to what they actually do. It is not what we call people. It is a duties test. Now that we've kind of explained, kind of what an exemption is and why some people are classified as exempt, why would an employer want to classify someone as exempt?
Well, I mean, the two most obvious reasons, I think, are, number one, it would mean that they would not be obligated to pay overtime pay. And so if you have an employee that routinely works 50 to 60 hours per week, it would mean that you wouldn't have to pay overtime for those excess hours over 40 hours. There's also, in terms of tracking time, you have to track time with non-exempt employees for overtime purposes. And so if somebody is exempt, there's not a time tracking requirement with respect to that position. And that can become a very significant issue when somebody is misclassified as exempt instead of non-exempt, because many times they don't have time records, and the Department of Labor will accept the employee's testimony as to the number of hours worked per week in the absence of any other evidence to the contrary. And so you may have an employee who says, I worked 70 hours a week, for the last 2 years. And, it, depending on the hourly rate, could be a very significant sum. So that's one of the reasons why employers, or two of the reasons why employers would choose to characterize someone as exempt.
And I find that lots of small employers will try to essentially classify their entire workforce as exempt for two reasons. One, as you said, not having to track hours, not having to deal with that, but also for budgetary purposes. They want to know that their payroll is the same every single week, regardless of the number of hours people work. And unfortunately, Department of Labor says, hey, that might be more convenient for you, but what do these people actually do? We need to actually figure that out and see whether they qualify as exempt.
I was just going to say, and of course, these types of claims are not covered by insurance. So in a small company, if you characterized your workforce, let's say it's 20 employees, and you characterize them as exempt when they're actually non-exempt, it's not unusual for these to be 6 and 7 figure claims. And for a small company, that could mean the difference between remaining in business and not remaining in business. So it is a very serious issue when, it's not a situation where it was just one instance of a misclassification, but instead an entire workforce.
Absolutely. Now, we talked about why an employer would want to classify someone as exempt. But of course, we also have to look at this from an individual's standpoint. And a lot of times, an individual will want to be classified as non exempt because they get overtime. That overtime premium, which is time and a half your regular hourly rate for all hours worked in excess of 40 in a work week. If you're putting in 45, 50 hours a week, obviously that can add up quite a bit. And there are a number of people who their overtime compensation outweighs their regular compensation. So there is an incentive for individual employees to want to be classified as non-exempt, especially if they work long hours.
That's right, Jeff. And it also applies to things like what we call waiting time, where an employee is engaged to wait before beginning services for the day, or alternatively, maybe employees have to put on a lot of equipment, or they have to take various trips during the day back and forth to different locations. And in these cases, employees will often argue, and most of the time successfully, that those hours should also be included in addition to the hours, that they may be actually in an office place or workplace environment, working their standard number of hours that they work during the week. And so those types of claims are also fairly common as well.
Absolutely. So a lot of times this issue comes up, whether someone has been classified properly or not, through a Department of Labor audit. Department of Labor gets a complaint from an individual employee, and they show up at your doorstep, at a company's doorstep, and say, hey, we would like to talk with somebody about whether or not you are paying your people properly. Jim, I know you've been called by employers at times when they have that Department of Labor person at their door. What do you tell them?
Well, when we have a Department of Labor request for an investigation or examination of the records, we get involved very quickly because typically we're getting involved at the stage where somebody has already submitted a request for documentation, and the company is they're trying to pull out records that they have and have not necessarily gotten to the point where they've actually evaluated whether or not the specific positions in question would qualify for the exemptions that we've been talking about. We'll get involved very early in the process because typically the turnaround time on some of these requests can be fairly rapid. It's not unusual for either a subpoena or a request to be served, and then the expectation that documentation will be provided, within 20 to 30 days. And there may also be either at the state or federal level, whether we're dealing with a Department of Labor at a state level or a federal Department of Labor, they may well request interviews with different individuals to get more information. That what we're trying to do is ascertain what titles in the company may not qualify for exempt status. These types of investigations come up in a number of different ways. Sometimes they can come up with an internal employee complaint where somebody feels that they're being taken advantage of, and they go to the Department of Labor and make a complaint. And typically the Department of Labor, and this is what we tell our clients, is they're not just looking at one individual. They're looking at the entire workforce. And typically when they do an overtime evaluation in terms of exempt status, they're also looking at whether sufficient wages were paid under the Fair Labor Standards Act. They may be looking at the documentation an employer has. So what we explain to our clients is that it may be a much broader review than just the exempt status issue. And what we like to do is to get out in front of that and evaluate for ourselves what these positions look like. And oftentimes, depending on the size of the employer, there is often certain patterns that you can predict. For example, There are times when it's a small employer and just a few positions are involved, and it's likely a less serious investigation. Alternatively, for example, in the retail area, over the years, we've represented a number of very large retailers. And in those situations, because the positions at issue are the same across the entire country, you might be in a larger retail organization talking about 3 to 4 thousand jobs that are the subject of the review. And so in those kind of situations, they are really critical and sensitive. And so it's important to have some in-person meetings and investigations and to go through it and develop, a strategy for what things look like. And ultimately what we'll do is we'll provide guidance on what we think the ultimate outcome would be of the investigation. And then obviously we'll negotiate with the Department of Labor for an appropriate resolution. Another way a lot of companies get caught up in these types of investigations is they go to a particular sector or industry because they know that the way most employers are set up in that industry is quite similar. And they literally can go from company to company to company and not have to recreate the wheel, so to speak, because they already know all the underlying information as to the positions and to the duties test. And they already have a head start in terms of what they're looking at.
And we're seeing that more and more, that focused audit, within an industry, or a targeted audit. And my experience is that the first thing that I want to look at when an employer calls me in this situation is I want to look at their job descriptions. Let's see what it is. Now, obviously, it's going to be what the employees actually do that is going to be controlling, not what the job description says, but that's at least a good starting point. And as you said, Jim, the Department of Labor will normally ask to interview one or several employees. And obviously, to the extent that you have the opportunity to prepare them for that interview, that's wonderful. And we obviously try to do that. But they're going to ask them questions to determine whether or not they are properly classified as exempt or should be non-exempt. They're going to ask them the hours they normally work. They're going to ask them whether they work through their lunch time or whether they're free to go, whether they get docked if they leave work early or come in late, because that's more a non-exempt employee situation than an exempt employee situation. And most of the time, employers have no rebuttal to what the employee says with regard to how many hours they work. Because they have been treated as exempt, they're not having their time tracked. They're not punching in, punching out, anything like that. So if an employee says, I worked 45 hours a week, not 40, and the employer has nothing to rebut that with, then the Department of Labor, when they make their determination, if they say this person should have been non-exempt, is going to order the employer to pay them 5 hours of overtime back for the last 2 years and potentially 3 years if it's willful. And that may sound like, that's not very much, but I just did a little math and, I like to share things like that. Only 5 hours. Let's say it's an employee who makes $20 an hour, so about $40,000 a year, not a top of the range person, but okay. So let's say 5 hours, $20 an hour times time and a half for overtime, times 52 weeks, times 2 years, you're at $15,600 for one employee who's misclassified. Now, if you have 10 employees who are in that same situation, you're talking $156,000. And as you said, Jim, that can be the difference between whether an employer is staying in business or not in business.
And we really haven't talked about liquidated damages, as you may know. By the way, the liquidated damages is just a fancy word for either doubling or tripling the amount that is owed. And many states and the federal government do recognize the concept of liquidated damages. Essentially a penalty is a way to think about it, to make sure that these types of laws aren't broken. And so in the investigation stage with the Department of Labor, they have the potential to assert liquidated damages. Most of the time they do not, even though they could. But in a litigation with a private individual, and their attorney, perhaps on a class-wide basis or a collective basis, very much we are often talking about liquidated damages and attorney's fees. And so that element of it can be very significant compared to the actual amount that's owed. And of course, there's another aspect to this too, which is ultimately the need to change the structure of the workforce potentially going forward. So that if you're dealing with the Department of Labor, we're not only talking about correcting misclassifications on a retroactive basis, but they're interested in making sure that these positions are classified correctly going forward. And so it may be necessary to redo or restructure these positions or to recognize them as being non-exempt on a going forward basis.
The other thing that I think is important to point out here is many times claims like this are brought by an active employee. And when that happens, there is a great risk of a retaliation claim because an employee has the right to bring a claim, bring a complaint to the Department of Labor regarding whether they think they've classified properly. And if the employer takes any adverse action against that employee, that could be deemed retaliation. And that's a whole separate claim. But there is a tremendous potential for that because usually employers are not thrilled with seeing the person every day who's brought a complaint against them that may cost them tens, if not hundreds of thousands of dollars.
And there are times too where it's not just one employee. So, looking at this from the plaintiff's perspective and how the plaintiff looks at these cases, they often look at whether or not a particular situation can be brought as a collective action or as a class action. Many of you may know in California and other states, that's a very common occurrence out there in this area. There are many, many collective actions or class actions. And in those types of situations where the positions are essentially the same throughout the organization and the issue is the same, they're very good cases to bring on a class-wide basis. So that's where you really do get these very significant claims. And in some of these larger companies, these are 9-figure claims. These are not small claims by any stretch of the imagination. And so it's important to understand that even in a situation where you might have one particular employee who feels that he or she is non-exempt and has been unfairly categorized as exempt, if they're in a position where there are another 50 or 100 individuals in this, occupying the same position, they could easily bring a collective action, and it's very common. So that's why these issues are really, really important many times, given the structure of the organization and the positions involved.
I agree. And Jim, I think this has been a good conversation. But as we wrap up here, I like to give our listeners a couple of takeaways from our discussion. Do you have one or two key takeaways that our listeners should be thinking of as they deal with this type of issue?
Yeah, I mean, the best time to deal with these issues is before they occur. The biggest and the best investment that companies can make is what I like to do is to do employment audits. And part of our employment audits definitely would consider misclassification issues. And what they would do is look at an organization early on and start making some determinations about how particular positions can be structured. I think it's a recognition of the local laws that regulate a workforce. One of the biggest takeaways, I think, is to recognize that if you were an organization with multiple offices across the United States, in multiple states, the laws that govern this particular area can be quite different. And it's really important to do that type of investigation early on in the process. The other suggestion would be to do this review on an ongoing basis because laws do change. Court decisions change what's considered to be an exempt position, say under federal law, as opposed to a non-exempt position. It's important to revisit this. There are many companies that have, for example, that I represent, where they've done a review, but maybe haven't done one in 5 or 10 years. And as time goes on, many things change in not only the federal level, but also at the state level, so that some of their particular offices, they may be out of compliance and not know it.
And I would say to our listeners that job descriptions help, but you need to make sure your job descriptions are up to date. Review them every 2 years or so. And if there are ones that are questionable, if you're not sure whether somebody qualifies as exempt or non-exempt, talk to your attorney and have them take a look at it, because as we've been saying throughout, getting this wrong is really expensive. And it's much better to do a self-check before it ever gets to that point. So with that, I want to thank you all for joining us on the Employment Law Counselor podcast, where we try to make sense of the world of labor and employment law. On behalf of myself and Jim Anelli, we thank you for listening. If you enjoyed this episode, please leave us a 5-star review, tell your friends, and subscribe to the podcast. For more information on this and many other topics, please visit our blog at www.theemploymentcounselor.com. Until next time, stay safe and stay compliant.